not vaccinated. So a lot of things are going on across the nation. And Jim, why don't you take it away?
All right, so I'm assuming that's me, Jim. So
yeah,
we're
sorry,
bounce around to Jim.
We got two Jims here. Right.
So I put that on the screen just because somebody has to laugh about a few things. So I'll put that if you missed it. There's nothing to see here. There's no issues. Just go home. There's no explosions. There's no panic. Just, relax, right? So Friday was such a nice, calm day, peaceful. The Sixth Circuit decided to just throw something out. It actually went back a couple of days before that. There's so much of a mess here. I'm not even quite sure where to begin. So I'm gonna walk through with you real quick, and then we're gonna talk to Jim about some ideas that he has about maybe how to handle things from a medium, large company size. So we've had all kinds of courts throughout the United States do all kinds of things. Now, everybody here is aware of the Sixth Circuit, or maybe you weren't and you just got the announcement on Saturday and said, hey, I'll just join Jim and see what he's doing today. But on Friday afternoon, the Sixth Circuit did something to set aside the injunction, but also the Fifth Circuit, whose injunction was just set aside by the Sixth Circuit, issued a different mandate. So there are literally dozens of injunctions that are being issued by various courts, but the ones that matter are any that you hear circuit, because the first through all of the circuit courts plus the federal circuit are one level below the United States Supreme Court. Sixth Circuit affects Kentucky, Tennessee, Michigan, and Ohio. The Fifth Circuit affects Kentucky because Kentucky decided to join a lawsuit there. So this is about to get really bizarre. So the ETS, let me get my highlighter back on. It didn't stay on. All right. So the ETS, as you will remember, at the beginning of November, there was an injunction issued by the Fifth Circuit. And then the ETS standard, that's the OSHA ETS for any employer over 100. Okay. So I want to make sure I didn't have the wrong slide up. So this is the one that the Sixth Circuit ruled on Friday. The Safer Federal Workplace, you'll remember that that's the one that the Eastern District of Kentucky ruled on right before Thanksgiving. So we have Judge Van Patenhope that ruled that the federal workforce task force mandate was not legal within the state of Kentucky. If that applies to you, go back to the update we had a couple of weeks ago and take a look at that, because that's current status for Kentucky. 3 states were impacted: Ohio, Kentucky, and Tennessee. Did not impact nationally because the Sixth Circuit doesn't like national injunctions. So then the one that is really kind of bizarre, if you're involved with Medicare, Medicaid funding for your company, Kentucky, last Wednesday, there was a ruling issued by the Fifth Circuit that included 14 states, one of which was Kentucky. We're going to walk through that a little bit. So this Fifth Circuit is a somewhat nationwide. The Sixth Circuit on that same date refused to hear the nationwide mask mandate en banc, meaning all 28 judges. What they ruled was, let's go with the first panel, 3-judge panel, and then we can do en banc after that. Well, right now we're in that limbo stage because we don't know whether they're going to do an en banc or whether everybody's rushing to the Supreme Court. There's about 100 petitions that have been filed with the Supreme Court asking the justice to rule on it. There's also a possibility of a filing with the Sixth Circuit asking that the 28 judges there rule on it. All over the map. So, big one that we're here for today, Sixth Circuit on the 17th of last Friday set aside entirely the Fifth Circuit ETS mandate. What did it do? Well, the majority of this, the 3 judges, the reason why I wrote this out is I want you to understand not about judge shopping, but it's just about the sheer numbers. So there were 3 judges involved. The one that wrote the opinion was appointed by Obama. The one that joined the concurrence was appointed by George W. Bush. The one that wrote the dissent was appointed by President Trump. It upheld the vaccine mask ETS that had been stayed since November the 6th, and it did it by a 2-to-1 vote. The importance here is the one person that voted, the reason why I have the name on Straunch, she voted in favor and wrote a very lengthy opinion basically saying the ETS is fine, OSHA has the ability, and we're going to walk through the majority, her ruling, saying OSHA can do what it did, it's fine to do what it did. The concurrence, the reason why she won and didn't lose, is because Gibbons said literally, I don't like either side here, but the judicial should stay out of this. This is all kind of in legislative, and as the judicial oversight watchdog of this, we really shouldn't have an opinion. We shouldn't be political. So therefore, I'm going to join the enforcement of this so that we stay out of it. Well, that's going to be a problem because, as I said, there are 28 judges on the Sixth Circuit that can vote en banc. The problem was that there are only 16 judges that can rule on whether to handle a case en banc or whether to let it finish through a 3-judge panel. The 16 judges, believe it or not, split equally down the middle, 8-8, but it was not an 8-8 on the vaccine mandate or on anything related to this case. It was our normal standard procedure is a 3-judge panel, and then after the 3-judge panel, we switched to an en banc request. So let's do this in the right order with the 3-judge panel, and then we'll decide whether to go to en banc. Several of the judges went ahead and wrote their opinion, basically calling out the ETS, saying whether it should or shouldn't be employed, but it split 8-8. The other 12 judges are retired/senior status. They don't have a vote on en banc. They just would have a vote once the en banc is approved. I don't know what's going to happen there. With the 8-8 vote, it was, let's have the 3 judges rule first, and then we'll consider whether to go forward with it. What the majority found, basically what the one judge found, because remember, Judge Gibbons didn't really join she joined the majority, but her concurring opinion was, I really don't have anything to say, we just should stay out of it. But what the majority found was the OSHA Act, or OSHA Act, requires the administration, OSHA, to issue an ETS.
Brent, good morning. I'm over here at Turbo Plumbing.
It requires OSHA to issue an ETS if it's necessary to protect workers from a grave danger presented by exposure to substances or agents determined to be toxic. If you go back to last January, I talked about that. Asbestos, black lung disease, the only other 2 times an ETS has been issued. They are calling this an agent. Well, they had a problem because now it's not a workplace agent, it's just in the regular environment. So then they said, OSHA has also issued regulations to impact infectious diseases such as HIV, hepatitis B, hepatitis C, and those are not isolated to the workplace. So since OSHA has done that before with requiring testing for people who are in the food industry and so on, then OSHA can do this as well. Then they had to push one other issue, which is an administrative agency, which is part of the executive branch, cannot usually issue regulations without direct authority from the legislative branch. It's called too much government. So they said, well, Congress, through the American Rescue Plan, actually expressly included funding for OSHA in the plan to carry out COVID-19 related worker protection activities. So therefore, Congress allowed this full-blown 153-page precursor to the rule itself. So since Congress allowed it, we'll allow it to go forward. So these are the three legs upon which the table is built. I don't know that it's a very sturdy table. I'm not sure that the judges, even in the Sixth Circuit, will allow this to stand as a whole, but they didn't have a choice because the three-judge panel had to rule first before the rest of the judges could weigh in. As I said, multiple plaintiffs have already filed for the immediate stay of the ETS with the Supreme Court of the United States. If you don't know what SCOTUS is, that's what that stands for. It is to be reviewed by Justice Brett Kavanaugh. This is not a political comment or statement. He is the Sixth Circuit Justice, meaning it was assigned to that particular justice long ago, and he has always been the Sixth Circuit Justice to which any kind of emergency relief will go. Multiple petitions were filed Friday, Saturday, Sunday, this morning, asking him to set it aside. Chances are there will be a ruling from the Supreme Court, but I also anticipate potentially a ruling from the Sixth Circuit en banc. If you listen to anything that Governor DeSantis said last week, he actually predicted the three-judge panel correctly. I also wondered the same thing on Thursday of last week. After the Sixth Circuit denied en banc, and the judges that were in favor of en banc were all of the conservative judges, and all of the judges that were against en banc, with a few exceptions, were all of the liberal judges. There were several of us that were reading the tea leaves going, oh, wow, the top secret three-judge panel must be ready to rule in favor of the ETS, because look at the ones that are dissenting are writing this big, long opinion saying we should take it up because the ETS is wrong and we should throw it out, so on and so forth. So I believe possibly by Wednesday, you could have a ruling from the Sixth Circuit that says we're going to take this up en banc and ask the Supreme Court not to address it yet. You could also have the Supreme Court before Christmas issuing something one way or the other. I don't believe Justice Kavanaugh will issue anything himself. I believe it will be a full, I could be wrong, but I believe the full Supreme Court will rule on this if the Sixth Circuit doesn't do something en banc this week. Most people, me included, believe the Supreme Court will take action before January 10th. You'll see why here in a minute that the January 10th is critical. I do believe that someone will address this before the 10th of January. This is why. So, wait, why am I going backwards? Sorry, new clicker. All right, OSHA issued a statement on their website. I'm gonna put it up on the page, then I'm gonna go back to this, but I'm gonna put this up here so you can actually see it. On Friday afternoon, OSHA issued this litigation update right here, basically saying we're really happy the Sixth Circuit threw out the Fifth Circuit's ruling, and therefore we now control and we're in charge. I'm putting this on the chat session really quick so you all can pull some information, because there's other information I want you to look at. Specifically, if you need to have a template on an emergency basis, go right here. If you click on it, it's a Word document. You can fill in the form, add your company's name on it, and at least you know it's OSHA approved. There's also a vaccine or testing and face covering sample. All of this is on there so you can implement if you can't afford to do your own, afford an attorney to go through it, or you don't have a safety officer. So that's the website that you need to look at from OSHA to get the information you need. OSHA basically said, hey, we're very gratified. We knew we'd win the whole time. Wink, wink. The funny thing is that when this was assigned to the Sixth Circuit, the government was the one that petitioned the Sixth Circuit to reassign to a different circuit because they thought that everybody on the Sixth Circuit was biased. So it was the government that challenged the Sixth Circuit. Sixth Circuit rejected it. It was the government that asked for an en banc. The Sixth Circuit rejected it. And now the government is gratified, and they knew all along they were going to win because the Sixth Circuit was going to say how awesome they were. It's just kind of been funny to read the tea leaves and see what they're filing, because they were the ones panicking that the Sixth Circuit got this with 28 judges and 19 of them being appointed by Republicans and thinking that there was no chance that they would prevail. They did. So then they said, okay, so we're going to delay enforcement for non-compliance. This is critical. I thought that they would extend deadlines. They did not. You are already supposed to be complying with the ETS because they don't care that it was postponed. You should have already been doing this by December the 6th, period. That's according to OSHA. However, OSHA ended up saying, you know what, we know there was a lot of confusion because even though we knew we were going to win, some of you doubted us, so here's what we're going to do. Because full vaccination expires in 15 days from today, and because you should have already done everything that OSHA told you to do with policies 2 weeks ago, OSHA said, quote, to account for the uncertainty created by the stay issued by the Fifth Circuit, they didn't say that, OSHA is exercising enforcement discretion with respect to the compliance dates for the ETS. To provide employers with sufficient time to come into compliance, OSHA will not issue citations for non-compliance with any requirements of the ETS before January 10th and will not issue citations for non-compliance with the testing standards and requirements before February 9th. So now, the December 6th date becomes January 10th, and the January 4th date became, this just said 5th. The December 5th date became January 10th, and the January 4th date became February 9th. That's important because you are already supposed to have put this in place. Why is that important? Because technically speaking, your employees can sue you for not having the policy in place. OSHA is not going to seek enforcement and issue citations before January 10th, but they didn't extend your deadline for compliance until January 10th. Your deadline for compliance was December the 5th. If you remember, I told you all back in November when the Fifth Circuit issued its nationwide injunction, and then when it got assigned to the Sixth Circuit, you all need to be planning for the worst. I don't expect this to be a long-term worst, but right now, you are under a policy that you were to have had in place by December the 5th. The stay was enforced on December the 5th. However, it's been lifted. So as of last Friday, you should have had a policy in place. OSHA is not going to enforce that until January 10th. That does not preclude individuals from challenging you for not having policies in place to protect the health, safety, and welfare. So one of the reasons why, honestly, I was very surprised to see that they didn't extend deadlines. They literally said, we'll give you a reprieve on our enforcement of those. I think it's a little underhanded. I think it's disappointing for companies because you have a right to rely on court proceedings. OSHA literally said, we're not going to enforce things. We're going to wait for the court to rule on everything. We're not going to do anything. And then on Friday, they said, bam, here you go, January 10th, but you should have already done it. We just won't issue citations. Don't panic, because I seriously doubt any courts are going to find anybody in non-compliance over the weekend. I seriously doubt that they're going to punish people for non-compliance. I seriously doubt employees are going to go out and start filing lawsuits. However, it probably could have been handled a little bit differently by just saying, hey, get it done by January 10th, get it done by February 9th, instead of saying, we won't punish you if you haven't done it until that date. Because you can't comply with the 14 days vaccine mandate by January 4th unless you literally start announcing today to everybody, go do it today, because 14 January 3rd. So I kind of wish they hadn't just said delay enforcement. I wish they had said get it done by the new deadline, but that's not the way it is. So that's why this is down here. You need to start implementation ASAP, okay? All right. What are you required to do? Number one, this applies to those employers with 100 or more employees. It does not matter whether they're seasonal, temporary, part-time, full-time. They did not define that. 100 or more, period. You must determine records of vaccine, and you must maintain those records for inspection by OSHA. You must provide specific information about vaccines, and I did short shrift this slide. If you remember back in November, I had like 4 slides talking about what all of these meant, what it means to maintain records, what type of testing you could allow. The person cannot self-test and self-report, but right now their spouse could test and write a letter saying, yep, they passed the test, I did it. But the individual can't do it for themselves. I know that's sloppy. I'm not suggesting you allow that, but that's kind of the way it's written right now. You must provide specific information about the vaccines that are available. You need to update that, by the way. I'm not a doctor, but Johnson & Johnson was declared on Friday to no longer be the most safe. They're not saying you can't get it, but as an employer, I don't believe you should be recommending it because of the potential hazards associated with that. You must also develop written policies. That's what I just dumped into that slide up there. You must implement those written policies describing the vaccine and testing requirements. Implementation is now January 10th. Vaccines are now February 9th. It allows covered employers to permit employees to undergo weekly testing rather than vaccination. Remember, you have to, this is kind of bizarre, people can go get tested anytime they want or vaccinated, but now under this new policy, you have to pay for the time it takes them to go get vaccinated during work hours because it's an OSHA standard and not just a CDC. All right, the new update for anybody on here that's medical, and this is the last legal update that we're going to chat a little bit about some of the other things. The Fifth Circuit, remember there are 3 ETSs out there. There's the one we just talked about, the Sixth Circuit's ruling on. There is the federal, and we talked about this, I'm going to go back up to it. Right here, there's the OSHA temporary standard. This is a Sixth Circuit one that just got thrown out. Safer Federal Workplace, this is the one the Eastern District of Kentucky said is not enforceable. Then there's the Centers for Medicare, Medicaid, CMS. That's the one I'm getting ready to talk about. Oops, sorry. So the CMS on the 15th, last Wednesday, the Fifth Circuit affirmed a previous district court injunction in all 14 states challenging the mandate. In addition, Texas District Court also alerted that it would be enjoined in Texas. So the Fifth Circuit decision, along with the one that we talked about last week in Missouri, there was one, or 2 weeks ago we talked about a Missouri District Court issued a 10-state injunction. So, and Texas was one of those. So now Kentucky joined in the Fifth Circuit. It was in Louisiana, and our Attorney General joined a lawsuit in Louisiana. So if you look at this, there are 24 states. I'm not going to list all of them, but some of you are in multiple states. 24 states that the medical injunction was banned. Kentucky is one of those. Ironically, Florida is not, and Florida actually has a district court ruling that says that law is fine in the state of Florida, and you have a governor saying we won't comply with any of the mandates. So Florida's refusing to comply, even though their district court said you shall comply. 24 states are covered by courts that have said this law is not enforceable. 26 states are covered by this is enforceable because no court has enjoined it yet. So on the 16th of December, the United States, the current administration applied to the Supreme Court of the United States to stay enforcement of Missouri and Texas. They did not include the Fifth Circuit yet, although I'm pretty darn sure by today it will be. But they're going to throw out the 10-state and Texas one. The Circuit will be joined with that, I'm sure. Supreme Court will need to rule on that as well. So everyone on here was enjoined across the board by either the Fifth Circuit that was the nationwide ETS, or the Fifth Circuit that was the 14-state, Kentucky included, that was issued last Wednesday, until Friday night. Now the ETS is back in force, and if I go backwards for just 1 second, this is what you are required to do if you have 100 employees or more. Also, remember my caution, which was if you are looking at, well, this doesn't apply to us at all because I don't have 100 employees. Remember, this applies to all of your suppliers that have 100 or more. The UPS, Federal Express, independent contractors, sub-vendors, anyone that has 100 or more all have to apply with this, or all have to comply. And some unanswered questions that are still completely unanswered is, what if the sub-vendor has, do you add each of your sub-vendors up to include those to be 100 because those are subcontractors under a contract that you have? We don't know yet because that's not yet been fleshed out. There are no regulations underpinning this. There's only OSHA's standard. I am going to put this up really quick. I'm going to give you this link. This is the ETS for healthcare that is currently being enjoined. If you need more information on it, the recommendation right now from OSHA is, yeah, you're a medical facility, you should still apply, you should still comply with it, even though there's an injunction stopping it. But if that applies to you, you should already know that it does, and you should start compliance with that. So that's your legal update. 1 minute over, but that 1 minute was me putting up the ETS for medical. And what I'm going to do, Lyle, is I'd like to get to Jim Grant, if possible, and have him start giving some information on what they're doing from a safety standpoint. I'll start trying to answer the questions that are in the chat and do those individually.
Okay.
Okay.
Yeah, that sounds good. And hey, I thought you were going 45 minutes, so you're under time. I think that's great.
I think we're going to have questions I'll need to answer too,
well,
but I
yeah,
wanted to make sure we had the employer position before I started answering them.
You got it. Okay. And so let me introduce Jim Grant a little bit more. He's been with Gray for 33 years now, and he's been in safety almost all that time. And some of you know Susan Brewer. She's been on here before and helped us. And I spoke with her over the weekend. She said, you know, we don't just need the HR guy. We need the OSHA guy. And this is what he's an expert at. And he's been working for a while on how they're going to handle this nationwide, because they have a lot of employees in Kentucky, but they have even more scattered all over the country. So, Jim, we appreciate your taking time to join us. Thank you very much. Jump in and tell us kind of what you all have in mind.
All right, well, thank you very much. And, you know, I'll take a quick second. You know, as far as Gray Inc. is concerned, we've got 13 operating companies. We've got over 1,800 people that are executing work across the country every single day. And, you know, the interesting thing is with the COVID pandemic is, you know, there's a lot of personal decisions involved with, you know, vaccination and where you land on masks and those type things. One of the first things that we did internally is we created a COVID huddle that sort of brought our leadership together and helped us come to a consensus on how we are going to handle COVID. So we were all, you know, leading our individual teams, you know, as a unified group. So one of the steps that we've taken is we have made the decision to respect our employees' decisions on whether they want to get vaccinated. So we're actually going to start we're going to steer away from the mandated vaccination and go to the road of one, we need to get their vaccination status, which we've created an app for that allows them to, one, provide the status, provide the documentation of their proof of vaccination, and then that'll obviously go straight to HR, and they can document that. We've also planned to communicate. As soon as the ETS came out, we started to understand more about what those requirements were. We started communicating to our team members just so, people had the opportunity to get their heads wrapped around it and start making maybe some of those decisions if they were on the fence. I think one of the biggest things, or the biggest hurdles that we have, is that we have such a remote workforce. And this is where maybe Jim can step in and correct us if we're taking the wrong path. But, when we saw the ETS coming, we actually went out and bought 5,000 self-tests. And our plan is to distribute those tests accordingly across our offices and the job sites that we have across the United States. And it's our understanding that, those tests can be used. One of the things about self-tests is that we understood that a representative of the employer had to witness the test. So when COVID first started, we actually created a position called a COVID coordinator, and all of our projects actually have them. So that coordinator would actually be the individual that's going to witness these tests, document them, and then get them to HR, and keep them secured. We plan to start doing that and having that in place by the 5th to be able to, again, start on the 10th. And then trying to think what else. One of the things that we've done, I think there's a question out there. I think the ETS actually requires that the employer has to pay up to 4 hours. I think they specify a limit of time for the vaccination. So, obviously we've been allowing that since the get-go. One of the harder decisions that we have to make, and we haven't really firmed up yet, is currently we're looking to test our team members, support the testing of our team members for about a period of 8 weeks. After that period of 8 weeks is over, then the actual team member may be required to bear the cost of those tests. And the ETS requirements, from the way we understand it, is that the employer doesn't have to do that if the employee is unvaccinated. So, but we do plan to cover that for a period of time. But then after that period of time, then it will be on the team members. It'll be the team members' responsibility. Also, along with the vaccination status, we've had to educate our people basically to say, or to give them the understanding, especially with the vaccination status, is, okay, if you're unvaccinated, or, there's individuals out there that don't even want to provide their actual status, whether they've had the vaccination or not. But if you don't provide your status, then obviously you'll be considered unvaccinated and will have to follow those rules. Any questions on that? Or I think I've pretty much given a broad view of it.
Good input.
Yeah,
Thank you, Jim. Yeah,
what
go
I
ahead.
was wondering, if I could, Lyle, we've gotten so many questions, and it's been a little while since we did this. What I was wondering is, this is from the slide deck 47, which was a month and a half ago, but let me just tell you, you all know this part. This is the 6 months and all of the deadlines, okay? Let me walk through, reduce this down. I wanted the question we've gotten that Jim kind of answered too as to what they're doing, and he's right with the testing as long as you are having it independently verified. So since a lot of questions on this, I thought what I would do is to point out to you what is it. Remember, these are out of date. So the slides you're going to see here, They point out the December the 5th instead of the January 10th, so just keep that in mind. But you're required to determine status. Acceptable proof of vaccination includes the vaccine cards, records from a pharmacy, healthcare provider, or any other official document. If you're unable to produce, if the employee's unable to produce this type of record, then there's an attestation, and we put this on the screen once before. Oops, I'm gonna copy it again and dump it in there so that you guys can see the attestation that, because I remember when I put this on there, the last time somebody said, can you please put that in the chat so that we can use that with our employees. There's the attestation that that person should add. You must inform them that if they put that attestation out there and they lie to you, they are subject to federal criminal penalties. They're not joking around, and if you've heard some of these enforcement things, make sure that you inform them of that. So this is the required vaccine. Compliance starts the compliance starts, yes, January 10th. The vaccine and tracking starts February 9th, okay? This was a question a lot of you were just asking about the testing and who has to pay for it. And this also breaks down unvaccinated into the different groups. If you report to a workplace at least once every 7 days, you have to be tested once every 7 days. If you work remotely and occasionally, you must be tested within 7 days of when you reported to the workplace. In each case, the documentation must be provided to the employer. And if you do not produce, if the employee does not produce a test, they are not permitted to come into the workplace. The employee must pay for the cost of testing, but the employers may be required to pay for tests pursuant to state law or collective bargaining agreements. This was the caution I gave you about if you have any operations in the state of Indiana, make darn sure you're complying, because Indiana has a completely different wage and hour deduction law. You can't take it out unless you have signatures and so on. Never allow your employees to go below minimum wage. And you may voluntarily pay for the test and may require more frequent testing if you so wish. Record keeping requirements, must keep a record of each test result. What records must be kept, and this is, remember I told you, red file, orange file. Don't put it in the employee's regular file. Don't allow the managers to see this. If you happen to be the manager, you have to act like you're not really taking it into consideration while you're making employment-related decisions. This is all of the different things that you're required to maintain for OSHA. Some of this is being tweaked. Remember, I told you that technically OSHA requires retention of records for the term of employment plus 30 years. The ETS suggests that the vaccine information only needs to be there for the ETS while it's in place, but it is very confusing because record keeping is not an ETS, emergency temporary standard issue. OSHA requires records to be maintained for the 30-year time period. It's still all over the map. We don't have any update on that either. Kinds of tests, this is where we were getting into what Jim just said. The way you're doing yours is entirely accurate once you said that you hired somebody to do the type of inspection of those. At home, over-the-counter are entirely acceptable. The only issue is you can't have somebody both self-administer and self-read. That's the concern that OSHA has. I guess what they're suggesting, I said this when we brought this out, if you have somebody self-administer and self-read, and they go, oh yeah, I'm fine, I can come into work, and then you find out that they've been lying to you, you don't have any independent verification. Then the question that somebody just asked about giving time off for vaccination or testing and side effects. You must provide up to 4 hours of paid leave to receive each dose of the vaccine. Reasonable time and paid sick leave to recover from side effects must also be provided. Employees may be required to use existing sick leave in order to recover from the side effects. And then the second bullet here was a typo that I had before, so don't worry about it. They are required to report positive test results regardless of vaccination status. Employees who test positive must be removed from the workplace. They're permitted to return to work only after receiving a negative test results, meeting the CDC and return to work criteria, or receiving a recommendation from a healthcare provider allowing a return to the workplace. But there were some things, and I'm not going to read this all the way through. We covered this. It is on our website as well as Hannah's website, Hannah Resources website, with regard to the PowerPoint slides. But Jim and Lyle, we got so many of those questions coming in that I thought it was critical to throw those up, because
good work.
It's almost like everybody needed a refresher. We also covered before what is a face covering, because OSHA actually described what the face coverings were.
We'll take these slides and add them to the slide deck that we're going to send out. We usually have it out by tomorrow. pretty fast.
Yeah.
Get that fast this week. But
just for clarity, I'd ask James this is, one of the things, seeing that gray ink is made up of multiple companies, as we look through the ETS and the way we are structured. And so I'll give you an example. Gray ink total is over 1,800 people, but we've got a sister company that only has 14 people. But the way our company is structured, the ETS makes this a gray ink policy, not a specific or based on the different companies' makeup. So in the way we're structured, we have decided, so even though one company only has 14 people, they make up the whole gray ink. So it has to go out to all companies.
Yeah, and there was a question, Jim, there was a question asked, Jim Grant, there was a question asked, and your answer there is precisely what I'm telling all of my clients as well. Since the ETS talks about part-time, temporary, sub-vendors, we are not playing games with organizations that have multiple sub-parts. It is, I'm going to use gray since you did, it's gray in total, not the little entity that has 14 employees only, because you do not want to run afoul of the ETS with the per day penalty or per penalty fine that they're suggesting. So we are highly recommending that you don't try to slice and dice this and say, well, you know what, manufacturing has an LLC over here and our accounting is a different ink over here, so we're just going to divide it and we're magically below 100. I would not do that, because the ETS is set up to try to force any company that could exceed 100 must comply. So they're not allowing you to go, well, how about if we have a division over here, or we have an LLC with a separate FEIN over here. If they're all controlled by one centralized company or one parent organization, you need to comply with this as one parent organization and don't play games with it.
Yeah.
Very well stated. No, well stated, Jim. That we've run into that already with companies. Jim, what were you going to say?
Well, one of the things I don't know the answer to this. Jim might. One thing I think we need to keep our eyes open on is what is considered vaccinated. I think there's some discussions going around there if CDC changes their language to say, once you have the booster, that is considered vaccinated, that, maybe some language could change or those expectations could change.
Yeah, and that was something that I thought about this weekend. I don't have a slide on it because there's no consensus. But one of the things that I saw this weekend was Dr. Fauci made a comment that the CDC definition of vaccination is nothing but a semantic issue. And that scared me to death, because it's not a semantic issue, it is a legal issue. Fully vaccinated is a definitional issue under the ETS. And yet his comment was, well, it's semantics because you're not technically fully vaccinated unless you've had the booster that we recommend that you get. Well, the ETS really is not defining what fully vaccinated is, but now we're hearing Johnson & Johnson 1 dose was not enough. They're literally now saying you've got to get something else. Now, they're not forcing it, but they're saying the 2 dose is better than the 1 dose, but neither the 2 dose nor the 1 dose equals the booster, and we think you ought to get boosted. But you all have to be aware, and this is not an employer issue, but it's a flying issue because all of you on here know I travel all over. I used to before COVID kind of changed that. I'm back to doing a lot of it. The airlines are talking about, are they going to require in the States, not like going to another country, but in the United States, fully vaccinated in order to travel? And then what are they going to constitute as fully vaccinated? Is that going to be boosted, or is it just the fully vaccinated? So to Jim's point, that's one of those issues where I've got all of my clients waiting for the shoe to drop. When are we going to need to start forcing boosted as part of the fully vaccinated? And what are we going to do then? Honestly, guys, I think that the ETS has to be changed because you can't do it under the existing ETS because boosted is not defined in the ETS. The other issue is you're going to have a tiered approach, I would assume. You can't treat the unvaccinated identically to the vaccinated but not boosted. So I think they've got to build in another tier. This is why Lyle started the whole thing off today saying, Jim says, both Jims probably, I think Jim Grant would agree with me on this, it's as clear as mud. We don't have a clue what we're going to do next because the orders from the 6th Circuit could be thrown out, the Supreme Court could weigh in, the 5th Circuit could be thrown out, the Supreme Court could weigh in, and CDC could come out and say, we hereby declare that if you've been vaccinated but not boosted, you're no longer vaccinated. And that could literally throw out everything that we believe is the status quo right now. We were all told back in, February to June, get vaccinated and you'll go back to normal. Now we're dealing with, if you looked over the weekend, cancellation. And by the way, I just got the notice right before we started today, the University of Kentucky, University of Louisville basketball game on Wednesday has been canceled. They're looking for a new opponent because Louisville's no longer able to play. So the everything you thought was back to normal is about to turn into something you're going to need to stay up to date. And I'm not sure where to even tell you where to go or what to do. The reason why I put the links on the page, bare minimum, start adopting the OSHA policy. Whether you agree with OSHA, whether you don't agree, start putting it in place because it's now the law, and they've at least given you a framework that you know they can't sue you, or not sue you, they can't cite you. This is what they put. It's a Word document, and you literally just plug in your name, and this tells the employees what the policy is. This is directly from the CDC, the OSHA website. On the first link I sent you, if you're medical, the second link I sent you in the chat. But you've got to start complying with this. This does go back to, and I wasn't trying to be Chicken Little with the threat or the warning, but I told you all, when the 5th Circuit issued its opinion, you have to continue to prepare as if it's going to be thrown out, because if it's thrown out, OSHA could come in the very next day, I think is what I said, and declare enforcement. Well, they did it the exact same day. Friday, they said, bam, we are now enforcing this. We'll give you a little leeway on getting cited, but you now are expected to comply with it. So I wanted to just put those on the screen, and also just confirm what you said, Jim, about the adding up of employees and the prepping. Honestly, it sounds like you've done an incredibly well-structured, well-thought-out policy with buying all of the tests and so on.
Yeah, in fact, I'd like to get the address for that because I had somebody ask me late last week how they might handle that. So if you could share that, Jim, that'd be super.
The address for the testing?
Where you purchased those,
okay.
the test.
We'll give it to you.
Okay. You got it handy, put it out there on the chat. But all right, some good comments. Do you think we've addressed most of the questions on the list, Allison, or are there others you want to bring to our attention? I certainly don't understand about United and wearing underwear instead of face masks.
Well, a guy got punished on United for wearing a women's thong underwear as his face mask.
I am behind the times.
You are. I keep up to date on all these things so I can report it to everybody, but then somebody scooped it. And they threw it out into the chat.
That's Keith Knapp. He's UK's representative to the governor's committee on this whole thing. I guess he has to keep up with this important, really important developments like that.
I have my own comments, by the way, about the Louisville Cardinals, but I'll leave them off the chat. So
yeah. That is pretty wild.
He's throwing his out there. I'm going to leave it to him.
Well, you know, we weren't supposed to play North Carolina this weekend, but the other two teams didn't make it. I think that's what, right? So it's happening all over. You know, this thing's coming back with a vengeance. My close friends that are immunologists say this is not as dangerous. The Omicron is not as dangerous to your health, but it's a lot more contagious. So that's a problem. Okay, are there other comments or questions? And Allison and Chase, if you all could take off the microphones, would anybody in the audience, we've still got quite a few people on here, like to share what they've been doing in their company, if they think it's really making a difference or, you know, having positive results? I'd love to hear from you.
So before we do that, or while we're doing that, you guys will notice the SHRM code, HRI code, the HRCI codes. You'll have to self-submit because we didn't even know we were going to do anything until Saturday. So I just wanted that up there, and I'm going to stop the share and let you all do what you do.
Yeah, sorry about that. We just couldn't get it. They don't like us when we call them over the weekend. They don't answer. Anybody want to share anything? Got a lot of great experts on here. I know that.
The one thing I'll tell everybody is I'm going to try not to have weekly updates over the holidays, but I would expect at minimum we may end up with an email update just giving you a quick legal synopsis if the Sixth Circuit adopts it or says that they'll handle things en banc, or the Supreme Court accepts it, we may do just an email update. I don't want to ruin your Christmas or holiday or New Year's, but some of these were critical, and this one was one we felt like we had to get it out to you as soon as we knew about it.
Well, thank you, Jim Grant. We really appreciate your taking time and being with us. And Jim Morris, as always, way to go. Thank you very much. I know it took you a lot of effort just this weekend to get it all together. Allison and Chase and Autumn, for all the work you do, keep us going. We really appreciate it. If nobody raises their hand really fast, we're going to sign off. Thanks so much for joining us. We hope you have a wonderful holiday. Hold on. I've been making rounds. Got to get ready again. Back to duty. Celebrating Christmas and the holidays. I hope people have a wonderful holiday. Be safe, happy, and we'll talk to you after the holidays unless something really crazy happens. Thanks a lot.
Thanks, everybody.